Court, all rise. Court is now in session. Please be seated or remain quiet. There's absolutely no talking in this court, please. Thank you.
Can I call this one first? Sure. Come up first is Aaron Hernandez.
Good afternoon, councilors. I think we have prosecutors reporting in. Yeah, councilors, let me ask, the matter of Commonwealth versus Hernandez, I assume you want your client brought up?
Yes, Your Honor, please.
All right. Very good. Yeah, remove Nancy's, just don't trip up the chair.
You want those motions?
Yeah, if I can take a look at what's been filed.
Three new ones. Okay.
I'll just read through the file just brought up before we do anything. So these are the only motions. Have any motions been filed by the prosecution?
No.
No, these as motions. Okay.
I haven't used search warrant on this issue this morning.
Okay. Great. What's that? Do you actually have it? Because there may be something else that I need to do. If you have it. Okay. Ms. Clerk, if you could call the case.
Come up first is Aaron Hernandez.
And the motion stands on for, it's a scheduled probable cause this afternoon.
Correct.
And councilors, if you could stand and introduce yourselves for the record, please.
Good afternoon, Your Honor. James Charles with the Commonwealth, with the District Attorney and Patrick Fonberg.
Okay, good afternoon, gentlemen. Counsel, if you could stand and introduce yourselves.
Good afternoon, Your Honor. James Sultan with Michael Fee and Charles Rankin for Aaron Hernandez.
Okay, good afternoon. All right, now the matter presents on the probable cause proceeding. Commonwealth?
Yes, Your Honor. Your Honor, the Commonwealth is requesting a continuance based on the nature of the evidence before the grand jury. This, as Your Honor will well remember, on June 17th, in the early morning hours, a murder occurred in North Attleboro. From that time, the grand jury began to sit and hear evidence. And as Your Honor well knows, the spring grand jury ended at the end of June, so June 27th. It was a 2-week lapse before then a new grand jury was impaneled. Since that time, that grand jury has heard evidence consistently. Approximately 24 witnesses have been presented, records, and other evidence, including out-of-state witnesses. So we're requesting, Your Honor, based on the evidence that needs to be presented, based on the fact that the last time we were before the court, there's been additional evidence that has been discovered, including search warrants that have been executed at an apartment of the defendant. And at that apartment, what they found was boxes of ammunition consistent with the caliber that was recovered at the homicide scene, that being .45 caliber, as well as in a Hum vehicle of the defendants. They found the magazine clip for Glock 45. The ballistic evidence has already suggested that a Glock was used based on the rifling profile, and in that Hummer, on the gear shift was the defendant's handprint, or strike that, his fingerprint. And on the box of ammo at the apartment was his fingerprints as well. There continues to be additional evidence that is being presented and considered by the grand jury. So, Your Honor, we would request most respectfully that in the interest of justice, a further date would be warranted in this case.
Thank you. And counsel, you should be heard on behalf
Yes,
of
Your
Mr.
Honor.
Hernandez.
Your Honor, 4 weeks ago, the district attorney sought and obtained a criminal complaint and an arrest warrant against Aaron Hernandez. He could have waited until the investigation was complete but for his own purposes, he chose to take those actions back on June 26th. And at arraignment on that date, I'm sure Your Honor will recall that the first assistant claimed the Commonwealth had a compelling case, replete with videotapes. He even presented a dramatic reenactment of the decedent's death. He made it sound like a slam-dunk case. Now, 4 weeks later, Your Honor, the first assistant says the Commonwealth is not even ready to show this court that it can meet the probable cause standard to hold Mr. Hernandez. It needs more time while Mr. Hernandez, who is presumed innocent and is sitting in a solitary cell at the Bristol County Jail, has to continue to wait. So he objects to this delay, Your Honor. Under the SJC's recent case in Perkins, which is 464 Mass 92, at page
92 and 103?
yes, Your Honor. The court clearly says that the Commonwealth is not entitled to proceed at whatever pace it might choose in marshalling evidence to establish probable cause or in presenting a case to the grand jury. There has to be specific good cause shown, and the fact that the grand jury is continuing to investigate, while that's a factor, that is not in itself sufficient. So if they should be ready today to at least satisfy that standard, if they can meet it, they should not be given an additional 30 days to continue to hold Mr. Hernandez without meeting at least that very basic test, Your Honor. And the defendant objects to the Commonwealth's oral motion to continue the probable cause.
So to be clear, does that mean the defendant is demanding that the Commonwealth go forward today?
That's correct, Your Honor. The Commonwealth should be required, as this court ordered 4 weeks ago, to go forward today with a probable cause hearing to meet the Meyer standard that supports his continuing to be held. They brought the case 4 weeks ago. They didn't have to bring it 4 weeks ago. Once the issue is joined, Your Honor, they have to come up with the evidence. That's not what Mr. McCauley says in court, makes representations, talks about what they say they have. It's evidence that the Commonwealth has to present to this court to demonstrate probable cause, and if they're not prepared to meet it today, Your Honor, the complaint should be dismissed, and let them come forward when they're in a position to come forward, which apparently is not yet.
Okay. Attorney McCauley, on behalf of the Commonwealth, and the Silva case is cited, I think, in one of the discovery motions, but it clearly is the law as it relates to probable cause. It's not a carte blanche for continuances. Commonwealth's position?
Yes, Your Honor. First of all, as I indicated, the timing of the case caused us to lose 2 weeks before the grand jury. There is evidence before this grand jury, and there will continue to be. It's not a question of investigating. It's that grand jury is sitting here in every case in Bristol County, and they only sit on particular days and for particular periods of time. They have been busy hearing this case and other cases from the first day they were impaneled. So we've done everything in our power to present it as expeditiously as possible, and requesting a further date based on the inability to have enough time before the grand jury, I think, is warranted in this case.
All right. Thank you, counsels. I appreciate hearing the argument. Clearly, the case is an important one for everybody affected, and the Commonwealth does have an obligation to get a probable cause proceeding scheduled in this court and to be ready for it. I do recognize that 4 weeks is a long time for somebody being held in custody, but the charge is, amongst others, a murder charge, and I would allow the Commonwealth's request for continuance. The defendant is entitled to a 30-day date. I would presume the Commonwealth should have this matter well in hand through the grand jury by that time. Do you have
Our anticipation to have that done by that time, Your Honor.
All right. Attorney Sultan, probably no real surprise that at least the first request that the Commonwealth would have would be allowed by the court for continuance. The Silva case recognized that it is not carte blanche, but even that case, I think there was references to continuances, at least at some point. Do you have a suggested date that you'd like to have the matter scheduled in this court?
Since the court has allowed their motion, I would...
We'll note for the record the defendant has objected.
Over my objection, August 22nd at 2 p.m. would be convenient to the defense, Your Honor.
Okay. I will state for the record that it's my intention not to be here. I'll be out of the state on that date. Anybody can handle a probable cause hearing in this court, but I just want to at least not, if it was important to the parties, I will not be here on that.
Well, Your Honor, it's important to us to be within 30 days. Obviously,
of course.
We think it should be today. So if the court wants to set an earlier date than that, that's even better. The sooner the better, as far as we're
It does not have to be heard by me. I have no personal jurisdiction over this case.
Your Honor, I'd ask for that date, August 22nd, 2 p.m.
Anything else, Attorney Sullivan, on just the continuance request?
No, Your Honor.
All right, we'll schedule it for August 22nd, 2 o'clock p.m. for probable cause. Now, I've also been served on the court several motions. Have you had an opportunity to talk amongst yourselves about these motions?
Yes, we got, Your Honor. I think we're in agreement as to both motions.
When you say both, I think there's actually, I thought there was more than that.
Your Honor, there are 4, but 2 of them do pertain to third parties, and I think that it's appropriate that those third parties have an opportunity to come to court and object if they want to object.
So the defendant's motion for order requiring preservation of third-party video evidence, that's
Both parties are not present.
Your Honor, they've just been served today. I would request a short date on both of those motions, but I don't think it's appropriate for the court to hear them in their absence.
okay. But clearly, the Commonwealth is on notice that anything that it has relative to these documents, there's a request. I would interpret that to mean a request to preserve evidence that's in the custody, care, or control of the Commonwealth, right?
So
All right,
that leaves the other 2, Your Honor.
Okay, so let's just be clear for the record. Defendant's motion for order requiring preservation of third-party video evidence. Defendant's motion for preservation of potentially exculpatory information are linked together. The potentially exculpatory information sounds like an ongoing obligation that the Commonwealth would have in any event, correct?
If they don't have them, Your Honor, I'm concerned about the...
I see. The other one is defendant's second motion for order requiring preservation of third-party video?
Yes, Your Honor. Both of those, each of those third-party motions is directed to a different party, and I would request that those be set for a hearing sometime next week, if possible, so that they can be heard and adjudicated by the court. The remaining 2 motions are motions that involve only the Commonwealth.
Okay. All right, so the third-party ones, I'll ask the clerk magistrate to start to docket those. We can set those up on a different date. Now, defendant's motion for necessary discovery and defendant's motion for preservation of potentially exculpatory information. Counsel?
Yes, Your Honor, thank you. We are in agreement with the defendant's motion for necessary discovery. The only caveat being that there are certain materials that have come into our possession by way of grand jury subpoena. Those obviously can be ordered by the court under Rule 5. I would respectfully request that that be done with a protective order, as I understand the case law to provide for. I think we're in agreement as to that. My brother would accept those materials with those conditions attached. That's correct.
The only thing that this court would need, I don't know that we would have a protective order under Rule 5. We could look to see, but I think the Commonwealth would have the burden of getting that together for the court's office. Okay. So, defendant's motion for necessary discovery would be allowed in total?
Yes, Your Honor.
With the caveat that any protective order that would have to be filed would be filed with this court. We would endorse it, and then each party would then have their responsibility to sign that and be bound by the terms of that protective order, correct?
Agreeable.
Okay.
Thank you.
All right. The other matter is a defendant's motion for preservation of potentially exculpatory information. Attorney Sullivan, do you wish to be heard on that motion?
Your Honor, I believe that the Commonwealth assents to that motion as well, if I'm not mistaken.
I do, Your Honor.
All right. Motion's allowed by agreement. All right, thank you. Are there any other defense motions that are present at this time you wish to be heard?
No, Your Honor.
Any motions filed by the Commonwealth?
No, Your Honor. Thank you.
All right.
Your Honor, we just need a date for those 2 third-party motions.
Right, the third-party motions, you asked to put it on the front burner, and certainly I can understand why. Next week would bring us to sometime, whatever date you'd like to.
How about Monday the 5th, Your Honor? It's a little bit past that, but is that
Okay,
acceptable to the court?
That's fine, that goes into the next week.
That's
if
10
you're okay
days.
with that, right. All right, so August 5th. Now,
Can we do that at 2 o'clock, Your Honor?
if people like 2 o'clock for some reason.
Well, because we come at 9, Your Honor.
I know, and you have to wade
it's a
through
long
the rest of the court business. We are a very busy court. No objection, Commonwealth, 2 o'clock?
No, Your Honor, that's agreeable.
And, Your
All right.
Honor, we can waive Mr. Hernandez's presence on that.
For that
day.
proceeding? Okay. The defense waives the defendant's presence for this proceeding on August 5th. Now, the other issue is notice. Somebody's got to send notice to the third-party record holder.
Of the hearing.
Clerk of the hearing, exactly. If the clerk's office, if you want the clerk's office to send a summons, then you've got to provide all that information, who the record keeper is and all of that. So we'll issue the summons from the clerk's office. If the parties agree that defense counsel can provide notice, then it's up to you folks. I don't know, I think the rule allows either process.
I don't have any objection to defense.
I mean, we're not into the Dwyer-Lampron situation here. These aren't privileged records or anything like that. These are just,
Just videotapes.
exactly,
We'll be happy to provide notice of the date and time of the hearing. Your
Okay,
Honor.
so clerk's office is not required to send out the notice. Defense counsel will send out the notice for waiving Mr. Hernandez's appearance for that date in this court, right? Are there any other procedural matters that we need to address at this point, counsels?
Thank you.
All right. Okay, we'll schedule the probable cause August 22nd. Defendant would remain held on the same process as previously, and
What time is that on the 22nd, Your Honor?
2 o'clock. You did ask for 2 o'clock, correct?
Yes, Your Honor.
Yeah. Okay, that concludes the matter directly with Mr. Hernandez. My understanding is that there's another series of motions filed by the media concerning records, and I know that Attorney Sullivan, you have an interest, and your client has a direct interest in this matter as well. The criminal case for right now is procedurally over here in this court. The other matter involves the media. I assume you want to be heard on that issue when we
Yes, Your
call
Honor.
that case.
My client be present for that as well.
That's what I was wondering. Do you want your client to be present for this proceeding?
Since he's here, Your Honor, I'd appreciate that.
Okay, and so, Mr. Clerk, do we have any other separate file to call? And it's an intervener, so there's no separate docket entry. Okay, in the matter of the motion for Gatehouse Media Incorporated, Associated Press, Cable News Network, CNN, United Communications Corporation, Eagle Tribune Publishing Company, and TVL Broadcasting, Inc. Motion to intervene? Any parties present? I wondered if you were here, counsel. Good afternoon. Absolutely. Wonderful to see you again. Counsel, if you could come forward and identify yourself for the record, please.
Good afternoon, Your Honor. My name is David Meyer. And quite frankly, Judge, I'm not sure whether my client, Mr. Wallace, is a party to this motion or not. Through your clerk's office, I received copies of the papers on Monday, but in reading the motion and the supporting materials, the moving party does not identify whether Mr. Wallace is actually part of the proceedings.
Interesting procedural posture. Counsel, do you wish to clarify any ambiguity on that issue?
Well, Your Honor, the scope of the relief requested by the press movements is delineated quite accurately in the notice of motion. If there is not clarity as to whether or not Mr. Meyer's client is involved here, simply because the press has been unable to determine at this point whether any of the sealed information remains impounded in the court files concerns his client. So it's the classic catch-22 where the press doesn't know what it doesn't know. And that, of course, is one of the primary reasons why the instant motion has been brought, to allow the press movements to inform the public accurately and contemporaneously about the documents that have been filed with this court.
If I might just be very, very brief, Judge. Of course. As I understand the papers, and I apologize if I'm not understanding them correctly, is that on behalf of the media, the moving party seeks to terminate impoundment orders on 2 arrest warrants.
Correct. That's the issue here.
As I understand it, frankly, from reading various media accounts, that there are arguably 3 people who have been arrested in connection with this case.
The issue is
there's a defendant before the court, there's a gentleman, Ortiz, who was arrested for various firearms offenses, and there's my client, Mr. Wallace. So when I say I do not know whether the 2 arrest warrants that the moving party seeks to be unimpounded relate to Mr. Wallace, I do not know if he's seeking to unimpound the arrest warrants for the 2 other individuals, that is, Mr. Mr. Hernandez and Mr. Ortiz, or whether my client is involved as well.
You probably don't have the benefit of this knowledge, but it's a matter of logic. There were only, though there were 3 defendants arrested allegedly in connection with these matters, only 2 of the arrest warrants have been impounded, 1 has not. And I will state for the record, there was no request, as I recall it, to impound the record of Mr. Ortiz. Mr. Magistrate, is that right? So by inference, by logical extrapolation, it's your client who is the subject. So you do have standing to be heard. It is couched in terms of a motion to intervene in the case of criminal case Commonwealth versus Mr. Hernandez, Commonwealth versus Mr. Wallace. So procedurally, you're certainly, you can be heard if you wish to on the issue of whether those matters should be unimpounded.
Just so that I understand it, that the arrest warrant, the affidavit which formed the basis of the arrest of Mr. Ortiz on the firearms charges was never impounded.
Correct.
And as of today is not impounded.
Correct. And there are other, counsel, I do recognize you from the previous proceeding involving the interveners.
Yes, good afternoon, Your Honor. Dina Al-Malawani from Bank of Protection on behalf of the newspaper company, which also intervenes in this matter.
Okay. And I do have a Globe newspaper motion that has been filed, also joining in the newest motion that was filed.
That's correct, Your Honor. It was filed this morning. I have a copy of the
All right. You wish to be heard in the arguments?
I do, Your Honor.
Okay, counsel, I'll hear you again.
May it please the court, good afternoon, Judge O'Shea, Mike Drive, Greenwood, Troy, Albany, New York, representing press movements. On this motion to vacate the impoundment orders with respect to the warrant materials as defined in the motion itself. Your Honor, I'm not going to belabor the law. We've been through this twice before with extensive hearings conducted through the courtesy of the court. The law is clear in the Commonwealth that search warrants upon their return are presumptively public records in the Commonwealth of Massachusetts by matter of common law and also by statute, Chapter 276, Section 2B. Their impoundment can only be justified through a showing of good cause. And while that is necessarily a contextual determination, it requires the court to take consideration of the relative interests of the parties and balance them under the circumstances of each individual case. It is nevertheless a very rigorous showing that has to be overcome by any party in a courtroom in the Commonwealth to justify the extraordinary remedy of impoundment. The same point holds with respect to arrest warrants, Judge O'Shea. Now, we were not able to find any case law from any court in Massachusetts concerning the impoundment of arrest warrants, but we cited 2 recent cases in our brief from Connecticut and Pennsylvania that established that arrest warrants, like search warrant materials, are similarly subject to the presumption of public access. If, as anticipated, the defendant in this case, or one of the other defendants allegedly involved, who has been arrested and is currently being detained, objects to disclosure of the warrant materials as defined on the press motion, the Supreme Judicial Court of Massachusetts has made clear that under that circumstance where there's a claimed opposition based on a fair trial right, that the standard is identical in substance to the constitutional First Amendment standard for public access. And that, of course, comes out of footnote 24 of the Sharp case, 432 Mass at 605. That requires a 4-part showing by the defendant. First, there has to be a substantial probability of prejudice that disclosure would impair his fair trial. Not a reasonable likelihood. The Press Enterprise 2 court, the U.S. Supreme Court decision, made abundantly clear that the lower standard is constitutional error. Second, there has to be a showing by the defendant or any other related defendant that disclosure cannot be protected by reasonably adequate alternatives to impoundment. Third, there has to be a showing that impoundment remains effective in protecting against the interest that allegedly would be prejudiced or compromised by disclosure. Fourth, any impoundment that remains ordered by the court has to be narrowly tailored. Not wholesale impoundment that is extremely disfavored under the law, where a narrower, more tailored approach can accommodate the interest being requested. So, Judge O'Shea, the press movements submit, as this court recognized in its ruling from the bench on July 8th, that none of the defendants who are involved in this case can satisfy the rigorous showing under the Sharp case. There is copious information that the press has reported about this case. It's in the public record. A great deal of it is in Reporter Linton's moving affidavit in support of the motion. I'm not going to belabor all of that information, Judge. We rehearsed our way through it the last time, but since we were here on July 8th, there are some additional pieces of information that I would call to the court's attention that is now in the public domain. There's now some of the details between the defendant Hernandez's interaction with the police when they first questioned him after the shooting death of Mr. Lloyd. And according to the documents that this court has already authorized disclosure of, defendant Hernandez's demeanor was argumentative when he was initially approached by police in question about Mr. Lloyd's shooting death. Second, when told that it was an investigation into a death, defendant Hernandez apparently slammed the door on the police detectives who were there to question him. With respect to Carlos Ortiz, one of the other defendants, in an alleged accomplice, he's told police, as reflected in documents now in the public domain, that Odin Lloyd, the day after Odin Lloyd was killed, that he and Mr. Hernandez went to an apartment in Franklin that was rented by the defendant Hernandez, and there they picked up a white hoodie sweatshirt that was similar to the one seen on video surveillance of defendant Hernandez the night he returned to his apartment, to his home, his residence, excuse me. Second, according to information that has now been released yesterday by authorities in Bristol, Connecticut, Mr. Ortiz has allegedly told investigators what the purported motive is here. And that, according to these documents released by Connecticut law enforcement authorities just yesterday, but now reported in the public domain, it is that Mr. Lloyd allegedly had information linking defendant Hernandez to a 2012 double homicide in Boston, and that defendant Hernandez no longer trusted the victim to keep that information quiet. With respect to defendant Ernest Wallace, another alleged accomplice who's been charged as an accessory after the fact to murder, when he turned himself in to police in Miramar, Florida, after this court had issued his arrest warrant, the documents released by Florida police say that Wallace told Ortiz that defendant Hernandez fired the shot that killed Odin Lloyd on June 17th. The point, Judge O'Shea, is that there is such a great deal of information concerning the circumstances of this case and the alleged involvement of defendant Hernandez and his accomplices that protecting anything any further is unlikely to be effective and therefore cannot satisfy the second prong of the test required under Shutt. And when we were in Your Honor's courtroom upstairs on July 8th, Your Honor expressed the idea that that was counterintuitive, I think was the word the court used. And
sounds familiar.
I can understand that. But I would submit, Judge O'Shea, that that's not what the law requires. The law requires, particularly when there is information in the public domain and already available and widely reported on, that militates very clearly in favor of transparency and openness rather than impoundment and secrecy. It's simply not our system, Judge O'Shea, even in very high-profile criminal cases, such as this one, that receive concentrated attention from the press and the public they serve, that we keep court records sealed and away from the citizens. Fourth part of the Sharp test, Judge, very briefly, we've argued this before as well. Even in cases that receive pervasive publicity, the United States Supreme Court has made clear that that doesn't necessarily mean that there's going to be an unfair trial because of a compromised jury pool. And The Supreme Judicial Court of Massachusetts has repeatedly emphasized that the better alternative to impounding court records is extensive, probing, voir dire, careful questioning of jurors conducted under the careful supervision and auspices of the trial court. That was the remedy that was endorsed by the SJC in Sharp. It was endorsed last year in August of 2012 by the SJC in the O'Connell case, both of which were very high-profile criminal prosecutions such as the incident one. The press movement submitted, Judge O'Shea, in the final analysis, a faithful application of the controlling principles, which make these documents that are the subject of the motion presumptively available to the press and public, require their immediate disclosure. Thank you, Judge O'Shea.
And anyone else on the moving parties? And then we'll get to the respondents after that. Counsel?
Thank you, Your Honor. I believe it's all been said. I'll just add on behalf of the newspaper company. It's my understanding that there are also police reports and police statements in the case file here, and the presumption of public access would apply to police reports and police statements just as it would to affidavits supporting a search warrant application, because those documents are filed in order to inform the court's exercise of judicial power, whether that judicial action is the issuance of the complaint in this action, or decisions on bail, or arrest warrants. And so the police reports and statements are part of the materials that the court is seeking in this motion. Thank you, Your Honor.
All right, thank you. Was there any other moving party? AP was here before, not present. Okay. All right, Commonwealth, any argument on behalf of the prosecution relative to the continuing impoundment of the two subject arrest warrants in these cases?
Yes, Your Honor. There is a matter of search warrants, and as to search warrants, the Commonwealth would propose redactions to the search warrants, Your Honor. And
well, let's be clear about this. The movements, the press movements, so-called, are seeking the unimpoundment of arrest warrants only at this time.
They've listed search warrants in their...
Specific search warrants in addition to the ones that have already been, because this is an ongoing circumstance. And I think, parenthetically, that it's part of the problem that we have when the Commonwealth asks to impound everything, including the motion to impound. The press then doesn't know which cases are being impounded and which aren't, which search warrants may or may not be impounded.
There are search warrants to which we would propose redactions, Your Honor.
Okay.
And I'd be happy to make an in-camera copy.
But not as it relates to the arrest warrants, because obviously it's not a return, it's a circumstance. Okay. All right, and let's start then with perhaps Mr. Hernandez. Lawyers wish to be heard. Attorney Salter?
Your Honor, I feel I'm in that old movie Groundhog Day. We argued all this before Your Honor, before a much smaller audience several weeks ago, and I'm certainly not going to belabor that argument, which was ultimately unsuccessful before Your Honor. Let me just say this. I understand the insatiable appetite of the media for information relating to this case. It sells newspapers, it sells ads, but the continuing dribble of stuff, day after day after day, which is the way this has been run, is systematically undermining Mr. Hernandez's right to a fair trial. And as important as the right of the media is to get their hands on all of this information, Mr. Hernandez's right to a fair trial, which is of constitutional significance, should be paramount. And frankly, the argument that so much stuff is out there already that who cares about releasing a little bit more, I think is an insulting argument. It's insulting to our system of justice. And if anything can be done to protect this man's right to a fair trial, this court should do what can to safeguard his right to a fair trial. The only other comment I want to make, Your Honor, is some of the materials that have been released already, I note, contain personal identifying information, his Social Security number, his date of birth, maybe other Social Security numbers in these materials. That kind of identifying information, which in my experience now has to be redacted by by counsel before counsel even files something with the court, that stuff should be redacted. And to some extent, it's too late now, the toothpaste is out of the tube, but to the extent the court is going to release yet additional information to the media, I would ask that any personal identifying information be redacted before it is unimpounded.
All right, but on that point, I'll invite comment from anyone affected by this. Two issues. One, when we had this hearing previously, there was an opportunity for counsel on all sides to offer to redact information. It was, in my estimation, an undue burden on our clerk staff to go through and parse out the finer points of 156 pages of documents that were going to be released. We also stayed the effect of the order to allow people any appellate rights if they wanted to. No. But my only point in mentioning that, not to sort of draw any kind of a blame issue, but realistically, how does that get accomplished if not through counsel? Defense counsel does one of the orders that we wanted to set up to make sure that Mr. Hernandez has all of his rights protected throughout the litigation of this case, was to make sure he had the documents that the Commonwealth had as it relates at least to the search warrants and the arrest warrants for starters. You've got those documents, and certainly the court, I think, has an obligation. I think even the press movements, so to speak, recognize that there are matters of routine redacting that we would hope to accomplish to protect the privacy rights of either Mr. Hernandez, other members of his family or acquaintances, and any other person who might be inadvertently caught up in this disclosure. So it does place the burden on the parties.
There's been a reference to police reports, other things in the file. I'll be happy to sit down in the clerk's office and go through whatever the court is about to unimpound and identify.
Well, you say it as if it's a fait accompli, which seems to sort of go to the issue that I think the law is clear that the court has an obligation to treat these as what they are, public records.
Well, if the court's not going to release them, then obviously I don't need to worry about redacting them.
Fair enough, I get it.
Judge, for the record, the
Yes.
press movements have no objection to redaction of what is conventionally understood as personal identifying information, whether it be of defendant Hernandez, any of his alleged accomplices, or any third party, bank account information, social security numbers, and so forth. We certainly agree that should be properly redacted.
All right. Does anybody else wish to be heard on the issue of the media reports and access? Counsel, on behalf of Mr. Wallace.
Thank you. Very, very briefly, I appreciate the fact that the court has already heard lengthy arguments and made a ruling several weeks ago. I would simply ask...
Just for the record, it did not affect your client, because that was one of the things when the motion was now filed, as it relates to, obviously by inference, your client. We wanted to make sure that you got notice so that you had an opportunity to come and be heard. So there's no adverse inference, I think, from the fact that there was argument made on documents relating to Mr. Hernandez. Your client stands on an even par and has certainly he can make every argument he wishes to.
I understand. I fully agree. I would simply ask the court to factor into consideration today what the balancing test, the fact that Mr. McCauley stood before the court and before the media and has indicated that he has a grand jury sitting. And that grand jury is sifting through the testimony of witnesses and various documents from both in Massachusetts and apparently from outside of Massachusetts. And that the grand jury presumably is considering whether or not there's a probable cause to charge certain people with certain crimes, whether my client or other clients. And to the extent that Mr. McCauley has very articulately suggested that he needs an additional 30 days to complete that legal process, that is the weighing of the testimony, the weighing of the exhibits, and quite frankly, the weighing of the credibility of the witnesses. I respectfully suggest that the court, to the extent that the court in its discretion is going to terminate the impoundment orders, that the court terminate them to be effective as of August 22nd at 2 o'clock. Or whatever date the Commonwealth can stand before the court and say, on behalf of the Commonwealth, we have completed our grand jury investigation. And this grand jury, objectively, independently, and without our vote on the evidence before us, or our view of the credibility of the witnesses who come before us, have voted out these indictments independently and objectively, and not based on what they've read about search warrants or affidavits or arrest warrants. And I would ask the court to consider, if the court is inclined to terminate the impoundment order on these two arrest warrants, bearing in mind that the third arrest warrant, that of Mr. Ortiz, is apparently unimpounded and available to the public. that to the extent that the arrest warrants at issue and any additional search warrants now at issue affect Mr. Hernandez and my client, Mr. Wallace, that those items remain impounded until such time as the grand jury finishes work.
All right, I'll invite comment. It's an excellent point. I assume, counsel, you've seen this coming?
Yes, Your Honor, and it's a novel conception of public access law in the Commonwealth of Massachusetts that disclosure to the press and public can somehow be held in abeyance until the grand jury finishes its work and returns whatever judgment it's going to return. The law says, with unmistakable clarity, that once search warrants and arrest warrants have been executed, filed, and returned, they are presumptively public until there is a showing of good cause. Conclusory averments that disclosure while the grand jury is impaneled is somehow going to interfere with that process is legally insufficient to justify their impoundment.
All right. Anyone else? Attorney Myers, in response, anything that you care to add? All right. Thank you. Well, we've been through this once before. The motions to unimpound were heard and tested under various legal theory previously, and it was my conclusion that they are public records. And the problem that we run into, of course, is that these matters are coming to us in pieces, and it becomes very difficult for us to alert the world, A, that we've impounded something when we've impounded the motion to impound, and B, to sort of have the people who don't know what the information contains try to make the argument that it should be revealed. It becomes a difficult process, no doubt. After hearing, though, I think that it is appropriate to release the arrest warrants that were prayed for. The search warrants that were returned, we have identified by separate search warrant docket numbers. Each search warrant that we issue has a docket number. And my inclination going forward on any motions filed by the Commonwealth would be to not impound the motion. So the Commonwealth, in filing a motion to impound, I don't think it would be appropriate, certainly with these cases where this has been ongoing, to impound that. So the idea behind it is if the Commonwealth files a motion to impound, it'll be a public record. At least the press will be able to know that there's another one that's been impounded, and you have a right to make this argument. Each search warrant return stands on its own. What I would do is this. I would do the same thing I did last time, and which is to stay the effect of this order for 24 hours to allow appellate review, if appropriate, by any moving party or responding party, and also to allow for the redaction. The Commonwealth conceded that there were items that they wish to redact. There were also matters that defense, at least as it relates to Mr. Hernandez, was seeking to redact. Obviously, Attorney Myers, on behalf of Mr. Wallace, you would have the same right as well. So that should, we'll stay the effect of the order until 3 o'clock tomorrow. It's a 24-hour notice. Appellate rights of the parties are protected. If they wish to exercise those rights, they certainly may. But in the meantime, the practical part of this is we would have to get the appropriate information redacted. Are there any other matters that we need to address at this point? From defense? Attorney Fee, anything else? Attorney Rankin, nothing from your point of view? Attorney Sultan? Attorney Griggle? Thank you. Okay, the matter stands concluded. Court is not in recess. We do have other unrelated matters that we'll have to get to in just a few moments, so we'll go from there.